San Francisco, of course, has made history being the champion worldwide for a very simple concept: equal benefits for equal work. And we challenged corporate America when we said that if there are two people working side by side, one has a married partner, one has a domestic partner, why is it the married partner gets all these benefits and the domestic partner doesn't? It's just not fair. So we passed a local ordinance, the first of its kind. We now have a state law that requires anyone that contracts, first in San Francisco, now in the state of California, with the state and does provide any benefit, doesn't require any benefits to be provided, but if they provide a benefit for a married partner, they must provide an equal benefit for a domestic partner. So we took on United Airlines. They sued us, we fought. Our city attorney won every battle, and finally United relented and not only said that they would comply in San Francisco, they offered domestic partners benefits to their employees around the world. And now, of course, every month we've got another few Fortune 500 companies offering domestic partner benefits, and clearly it's the way that business is going to be done in the 21st century. No sizable corporation could imagine being able to hold on to any kind of talented staff if they didn't provide equal benefits. But it came to my attention that San Francisco, aside from being the champion of equal benefits, was a big old hypocrite because we were not providing equal benefits to some of our own employees, and that was to our transgender employees. Very few of them, probably not as many as a dozen out of a workforce of 27,000. But I learned that if a non-transgender employee of the city and county of San Francisco was in need of some psychotherapy or some hormonal therapy or needed a mastectomy or a hysterectomy or a variety of different medical treatments, city health plan would pay for all of it. But if a transgender employee needed the identical medical treatment, city health plan wouldn't pay for any of it. Equal benefits for equal work. And it wasn't necessarily out of any mean-spiritedness, it's just that the actuarial studies hadn't been done and we hadn't contracted with our health provider to provide those services. And so we set out to craft a local ordinance that would change the city's health plan. One other thing I learned, strange little quirk to the city charter, was that even though it only takes a simple majority, 6 of 11 supervisors to pass a $5 billion budget, to amend the city health plan, you need 9 out of 11, a supermajority. Just a strange thing that should have been amended out of our city charter long ago. So I had to get 9 out of 11 votes. We were able to do just that. And now, as a result of San Francisco doing this, there are health plans such as Kaiser and Blue Shield, which are now doing the same. So we've impacted the private sector so that there will be access for needed medical care for transgender individuals. So got to Sacramento, and upon my arrival, we formed our first LGBT legislative caucus, first of its kind in the country. My first 2 years, there were 5 of us. Now there are 6 of us. I chaired it last year in its second year. The first year out, we came together and decided we would focus on 4 bills, and that's really among the many reasons that we decided to come together, that we should not be working at odds with each other. We should be considering what bills we might like to do as a caucus and identify them, give them a top priority, and communicate that to our colleagues and to some of the other caucuses within the larger Democratic caucus, the Women's Caucus and the API Caucus and the Black Caucus and the Latino Caucus. And the 4 bills that first year included a bill that I just described to you, the Equal Benefits Bill, statewide. We also did our Comprehensive Domestic Partners Bill, AB 205, and then I authored a bill that amended the Fair Employment and Housing Act to include gender identity for purposes of preventing discrimination in housing and employment as a basis for discrimination, and a 4th bill which will probably come to mind in a moment. And remarkably, we were able to get all 4 bills passed and to Governor Gray Davis's desk, and he signed all 4 bills just prior to his being removed from office. A remarkable accomplishment, a really astounding accomplishment. Keep in mind that, and I'm sure the Senator remembers some of this, it took us 22 years, we California as a legislative body, to add the word sexual orientation to our Fair Employment and Housing Act. Fair Employment and Housing Act has a long list of those categories of individual, race, religion, creed, nation of origin, mental disability, physical disability. You get the idea, all illegal to discriminate on those bases in housing and employment. It took us 22 years to add sexual orientation. It was a huge bill. Art Agnos was Assemblyman at the time, introduced it first in 1977. I think it took until around 1990 to actually get it passed, and he brought it back every year, wasn't it? It was AB 1 and AB 101, year after year after year. This was a radical notion at the time. And it finally got passed, got to Pete Wilson's desk. He was up for re-election that year, and he pledged during his campaign for re-election that he would sign AB 101 if he got re-elected the following year. Well, we got it to his desk, and then he vetoed it. And there were riots in the streets in San Francisco and in West Hollywood. And then there was no more AB 101 for a number of years through the 90s. Finally, it got to Gray Davis's desk in 1999, and he signed it into law. 22 years. So here in my first year, in our first year of our caucus, we put 4 major bills forward, and they all passed, and they all got signed. So we're very full of ourselves, as you can imagine. We just think we can change the world. So, as you probably know, we're moving forward with our marriage equality bill. Introduced it last year. The story behind that is the following. I had been involved with the issue of equal protection under the law for same-sex couples, first as an activist and then as an elected official for probably about 7 or 8 years. And for all of those years, up until November of 2003, after the decision of the Massachusetts Supreme Judicial Court, I had always personally felt that I wanted the bottom line for myself and for my community. I wanted the rights, privileges, benefits, and yes, the obligations and responsibilities of marriage for same-sex couples, but I didn't think it was necessary to fight a war over a word, which, of course, we're now enmeshed in that war. But, as I said, it was the Massachusetts justices which changed my mind and heart forever. They, like the other 2 state Supreme Courts which have dealt with the constitutional issue of denying marriage licenses to same-sex couples, which, of course, San Francisco has now challenged California state law, is presently being considered by the Superior Court in San Francisco. We expect to hear a decision within a week or so, and then it will probably be appealed possibly directly to the California Supreme Court. We might have an answer from them within 18 months. But Massachusetts was the 3rd court to deal with the constitutional issue. Hawaii and Vermont before Massachusetts, ruling as Massachusetts did, that there is no constitutional basis for this discrimination. They also said that our history teaches us that separate is seldom, if ever, equal. But they went on to say something which was revelatory for me. They said, the only remedy to this identified discrimination will be marriage itself. No other parallel constructs, such as civil unions or domestic partnerships, will do, they said, unlike Vermont, which said to its legislature, you have to correct this discrimination one way or the other, parallel construct or marriage. Massachusetts says marriage and marriage alone. And the reason for that, they said, was, in their words, anything short of marriage would perpetuate a destructive stereotype that suggests there's something inherently inferior and unstable about the way we love. And I'd never thought about it like that. You know, I've been an out gay man for 35 years. I've been called a lot of things in my time, but I never had heard anyone disparage the way I loved. When you think about it, that's our common humanity. That's the one thing all of us walking this planet have in common, irrespective of where we were born or the language that we speak, color of our skin, is our ability to love and our desire to love another human being in an intimate and committed fashion. So to disparage the way we love is a direct assault on our humanity. And at that point, I thought, I'm ready to fight a war over a word. And so that's where we are today. So it was back in November of 2003, I sat down with my staff and I said, let's do a marriage bill. They were a little surprised themselves. The ink on AB 205, the Comprehensive Domestic Partners Bill, wasn't quite yet dry and wasn't going into effect for another 14 months. But I thought, now's the time to do a marriage bill. So we were planning our course of action, all very excited, of course. They were trying to rein me in. Session was reconvening in January. I wanted to do it first day. They said, whoa, we'll do it in February on National Freedom to Marry Day, which is February 12th. We just had another anniversary of it. And thinking, this is going to be big news, and we're really jazzed. And then, of course, on Monday, February 10th, I got a call from my mayor telling me what he was planning to do on February 12th. So the rest is history, and bless his heart for doing so. The bill kind of got buried in the midst of 4,000 marriages. But it was very critically important for the movement of our bill last year that San Francisco and then subsequently Oregon and subsequently New York and then Massachusetts issued marriage licenses legally to same-sex couples. Because quite honestly, without all of that, which is really substantive confirmation that this is a national civil rights movement, I would have been up there in Sacramento with this bill, and many of my colleagues, I'm sure, would have thought, oh, there's just another crazy San Francisco legislator trying to change the world. So we were really well positioned to move the bill forward in the midst of all that was going on across the country. And this became the #1 issue of last year. And we made great progress last year. We started with about 20 co-authors of assembly members and senators. Through the course of the year, we got full support and endorsement from 4 statewide elected office holders, which is very significant that people running statewide would embrace this for the civil rights issue that it is. That was the Secretary of State, the State Treasurer, the State Controller, the State Insurance Commissioner. And then even more significantly, the Speaker of the California State Assembly, Fabian Nunez, said he would join me in the new year with our new bill as a joint author, which is the highest level of co-authorship, literally putting his name next to mine on the cover of the bill. And you can be certain that a speaker doesn't do that expecting a bill to fail, because it really is a test of the speaker's leadership and ability to run his caucus, if not the House, to be able to put a bill that he has identified as top priority to the governor's desk. In fact, he's been quoted in the LA Times as saying, we will get the marriage bill to the governor's desk this year. So realizing that we didn't have the necessary votes to prevail last year, knowing that an election was coming up, the issue was making a lot of my Democratic colleagues uncomfortable, at least some. There was no need to proceed and to fail on the floor. It was too important of an issue, and we weren't trying to make a point. We're trying to change the law. So I decided, along with our sponsor, Equality California, to take a half step back and to come back with a new bill on Monday, December 6th, this past December 6th, the first day of our new session, with another marriage bill with the intent of taking it all the way to the governor's desk this year. So we're in that process now. Now, the new bill differs from the earlier bill in some slightly minor but at the same time significant ways. The previous bill was entitled the Marriage License Non-Discrimination Act, and the new bill is entitled the Religious Freedom and Civil Marriage Protection Act. We added a new section, first I should tell you the core of the bill, which is amending Section 300 of California's Family Code, currently defining marriage as a civil contract between a man and a woman. Our bill would amend that to read a civil contract between two persons. But the new section we added really restates the obvious First Amendment protections to freedom of religion, but because the core of our opposition is coming from a religious perspective, we thought it was important to go right to the heart of that opposition. And so we added a section that states that no minister, priest, rabbi, or any religious institution which does not recognize nor solemnize same-sex marriages will be required to do so. So just put that to rest. And additionally, we added a finding which we took from the 1948 California Supreme Court decision. You may know that California was the first and only state to end the ban on interracial marriage prior to the Earl Warren 1967 Supreme Court decision, finally ending the ban in this country. So our justices in 1948, ending that ban, stated that marriage is more than a civil contract to be regulated by state law. They said it is a fundamental right of all citizens. They used the word free men. They meant citizens. And they said any legislation infringing upon that fundamental right must be based upon more than prejudice and must be free from oppressive discrimination to comply with the constitutional requirements of due process and equal protection under the law. It says it all. It says it all. Prior to 1977, marriage was defined in our family code as a civil contract, period. The words man and woman weren't added until 1977. The year after, the legislature passed a bill, signed into law by then Governor Jerry Brown, that ended the sodomy laws here in California. And very quickly, the legislators figured out, just as Justice Scalia did when the Supreme Court ruled in favor of Lawrence versus Texas, ending all the sodomy laws in this country, that if you don't have sodomy laws and you define marriage as a civil contract, guess who can get married? So they quickly added the words between a man and a woman. Clearly done out of prejudice and oppressive discrimination, unable to comply with the constitutional requirements of due process and equal protection under the law. So we put that in our bill as well. So we're moving forward. We're now up to about 30 co-authors, and we'll be in committee probably sometime in May. The first stop will be the Policy Committee, the Judiciary Committee on the Assembly side. We expect success there, given that all the Democrats, which is more than majority of the committee, are all co-authors of the bill. It will then move on to the Fiscal Committee, the Appropriations Committee, where all the Democratic members, again, a majority of the Appropriations Committee, are either co-authors or publicly in support of the bill. So we then move to the floor of the Assembly. Now, I can't tell you we've got a majority, which is 41 votes today, and given the nature of the bill, we probably won't know exactly who the 41 are until the day we hope that it passes. We've certainly got a base of 30, 32, or maybe even 35, but there'll be folks wiggling around and trying to figure out what to do with this up until it gets to the floor that day. But we feel very confident with the stage that we have set and the foundation we have built that we will be able to get it off the Assembly floor, and then it goes to the Senate, and the Senate is usually the less challenging of the two houses. And then it would go to the governor's desk, and we will allow Governor Schwarzenegger the opportunity to make history, either by vetoing the bill or by signing the bill, given that this is the first bill of its kind in the country. So I hope can get a sense of the excitement I have as we move this forward. The caucus is dealing with a number of other issues this year, and we'll have a handful of bills that we move forward as well. But this certainly is one that I think has the most significance for the community. And I recognize that there are some people who have no interest in the institution of marriage. Some think that it's our intent or interest in marriage is just mocking a heterosexual custom. Why would we as revolutionaries, social revolutionaries, be interested in it? But the same as with access to serving honorably in the military, and as a conscientious objector, I never had an interest in doing that myself, but I will fight, of course, to make sure that everyone, every citizen in this country has their right to be able to serve in the military should they decide to do so. And you know, historically, basic tenets of citizenship, the very basic tenets of citizenship, have been just that: service in the military and the right to marry. Without that, there isn't citizenship. So that really defines that we are, in fact, second-class citizens in this country. And I'm just fascinated that I've got colleagues that I work with on a daily basis who can look me in the eye and tell me they think that's just fine. So due to political constraints, I'm well aware that some members, mostly on the Republican side, will never embrace this and won't get any support. Give you the idea of how severe the partisanship is in Sacramento. I authored a resolution, non-binding legislation, a resolution last year which declared June LGBT Pride Month in the state of California. 48 out of 48 Democrats voted for it. Not a single Republican would vote for that resolution. So it's unfortunate. It's unfortunate because I think if either of us are out of step with our constituents, it's on the Republican side. We have polling that shows that 62% of California Republicans support equal protection under the law for same-sex couples. That's amazing. And that happened very quickly in just the past couple of years. Public opinion is shifting very, very fast. Now, they believe, at least 50% of them, about 12% support marriage equality, but of these 62% of Republicans in California who do support equal protection for same-sex couples, clearly 50% believe that domestic partnerships gets us there. And it's our job to communicate and inform and educate them that it does not. Not only are the 1,100 benefits that come from the federal government instantly given to Britney Spears when she went off to Las Vegas that night, but denied to us and to couples who have been together, like Del and Phyllis, for 52 years. Law considers them to be legal strangers. And that's a serious inequity. And so we need to make sure that more and more Californians understand that. Also that you can't have portability with domestic partnerships, given that no other state has it, no other state recognizes it, no other nation has it. Marriage, of course, portable across state and national boundaries. And a couple other minor things that we weren't able to do with domestic partnerships here that marriage is afforded. So as I advocate for this bill, of course, it's important to put a face on the inequity and put a face on the human suffering that is incurred as a result of the current inequity in the law. And I use a few examples of a surviving domestic partner who's lived a lifetime with his or her partner who has now died. Married partners are exempt from the reassessment of their home upon the death of a married partner. So you've got a husband-wife, house is in the husband's name, he dies, the wife inherits the house. It's not considered a transfer of deed, so the county does not reassess the property. Property taxes don't go up. But in this hyperinflationary market here in California, where you've got a couple living in a home for 30 or 40 years, they're paying $500 a year property taxes, partner dies, domestic partnerships aren't exempt from Prop 13, as I've just described, married partners are, and the new property tax can be $9,000, $10,000 a year. So in the midst of her grieving of her lifelong partner's death, she's priced out of her home. Why would we want state law to do that to somebody? I've got any number of teenage friends whose two mothers or two fathers can't marry, and they live in daily fear that if something happens to their birth parent, given that their parents are considered legal strangers in many cases, in fact, especially if one is foreign born and they can't become domestic partners out of fear of being chased out by the IRS, if something happens to the birth parent, she would be in foster care the next day. Why should a 15-year-old girl have to wake up with that fear every day? Because of state law. And then, of course, married partners, one's native born, the other is not, binational couple, the married partner can sponsor the non-native born partner for citizenship. Can't do that with domestic partners. So I know dozens of couples who are now faced with the choice of either splitting up or leaving the United States because this country won't allow them to stay here. There are only a handful of countries that do have full marriage rights for same-sex couples around the world, but there are nearly 24 countries which allow for a sponsorship of citizenship for a non-native domestic partner. So we could be at least doing that. So I can ramble on much longer than you would like or I have time for, so I'll quiet down. With regard to Dr. King, as we saw the results of the November 2nd elections and some of our higher electeds suggesting that the defeat of John Kerry was due to the issue of LGBT civil rights or marriage equality, too much, too fast, too soon. Tell that to Del and Phyllis after 52 years. I thought I might find some wisdom in Dr. King's writings and came upon this book of Why We Can't Wait. And it's been a great companion these many months since. Talking about timing, he says that human progress never rolls in on wheels of inevitability. It comes through the tireless efforts of men and women willing to be co-workers with God, talking about how one white brother, he said, in Texas, wrote to him that said, all Christians know that the colored people will receive equal rights eventually, but it's impossible that you are in too great a religious hurry. And he makes point, no, time is neutral. It takes hard work to make these changes. And then he also, this is a very powerful excerpt, again, with regard to why we can't wait. He says, perhaps it's easy for those who have never felt the stinging darts of segregation to say wait, but when you have seen vicious mobs lynch your mothers and fathers at will and drown your sisters and brothers at whim, when you see the vast majority of your 20 million Negro brothers smothering in an airtight cage of poverty in the midst of an affluent society, when you suddenly find your tongue twisted and your speech stammering as you seek to explain to your 6-year-old daughter why she can't go to the public amusement park that has just been advertised on television, and see tears welling up in her eyes when she is told that Funtown is closed to colored children, and see ominous clouds of inferiority beginning to form in her little mental sky, when you take a cross-country drive and find it necessary to sleep night after night in the uncomfortable corners of your automobile because no motel will accept you, when your wife and mother are never given the respected title Mrs., when you are forever fighting a degenerating sense of nobodiness, then you will understand why we find it difficult to wait. There comes a time when the cup of endurance runs over and men are no longer willing to be plunged into the abyss of despair. Can you imagine writing like that? Speaking like that? So, highly suggested. Well, I appreciate your sharing the evening with me. I thank you very much.